And he said to them, go into all the world and preach the gospel to all creation. So universally go and preach. We'll come back to the universal call of preaching the gospel. That is our main point we get from this passage. This is what I got to apply to me and you got to apply to you, is the call of Jesus to bring the gospel to everyone. It is a responsibility of individual believers. Even if you're not an evangelist, your neighbors are in need of hearing about Jesus. If they were in need of something else and you had the cure for their problems, you'd be morally obligated to give it to them, right? And we need to tell people about Christ.
Jesus said, the gates of hell shall not overcome the church. I look at the assassination of Charlie Kirk. A seed went into the ground. There were 1,500 of his Turning Point USA chapters in schools when he was shot, the day he was shot. Do you know now there's over 80,000? 80,000 chapters of Turning Point USA. The church cannot be stopped. There are more people being martyred in this generation than ever before. There is tribulation that the saints are going through. It's not the tribulation, because the tribulation is the wrath of God.
There's something evil behind this. This is not just men doing things. There's something truly supernatural evil about it.
The defense team for the man accused of killing Charlie Kirk now says the bullet used could not be matched to the gun Tyler Robinson allegedly shot.
It's been nearly 7 months since conservative political activist Charlie Kirk was shot and killed during a Utah Valley University campus event on September 10th last year. Now, attorneys for Tyler Robinson, the man charged in Kirk's killing, are asking to delay his preliminary hearing to review a mountain of material they say could help his defense. The defense claims in an ATF report summary that the agency, quote, was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson.
Doesn't mean that those bullets aren't the same or that they aren't connected. It just means there isn't enough evidence there to come to a conclusion. It is sometimes difficult to match bullets that were recovered at autopsy with bullets that are associated with a defendant's gun. And that could be based on lack of evidence and lack of markings on those bullets.
Robinson has been charged with aggravated murder in Kirk's death. He has not yet entered a plea. Prosecutors intend to seek the death penalty.
Robinson hid the gun and told his roommate to delete incriminating text messages.
Prosecutors allege Robinson admitted to killing Kirk in those text exchanges.
Roommate, you weren't the one who did it, right? Robinson, I am. I'm sorry.
The inability to conclusively match the bullet won't necessarily damage the prosecution's case.
The prosecution has other evidence to rely on. This does not completely undermine their case.
The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
Thank you.
We are in recess.
State of Utah versus Tyler James Robinson. Good morning to the prosecution.
Good morning, Your Honor. Richard Novak, Stacey Visser, Michael Bird, present. Mr. Robinson.
Good morning to defense. Good morning, Mr. Robinson. Before we begin, I want to address, in an abundance of caution, we have turned off the microphones at the desk so nothing can be captured. You have to come to the lectern. What you have to say is important. To be cautious.
Thank you. Your Honor, I actually think the court reporter filed the transcript with the court last night.
Mm-hmm. Just going to agree that that's, my understanding is that's been filed.
I wish to address media coverage and related considerations as it relates to this hearing. We've turned off the microphones at your counsel table, but just to be mindful that microphones, even from the lectern, can pick up conversations. Counsel may wish to consider using screen protectors on laptops, taking reasonable steps such as covering one's mouth when speaking to avoid the inadvertent capture of private communications, whether by camera, microphone, or by those present in the courtroom. I want to turn to the state as it relates to discovery and just want to see if we could have just a brief update. Mr. Greenander.
For the record, sent another batch of discovery to the defense as recently as last night. Files that we, in our possession, we have provided 93.9% of those files to the defense at this point. We are candidly still waiting for some information. We had a meeting yesterday morning with some of our federal law enforcement partners, the FBI, the ATF, and talked about this issue of discovery. Impressed upon them the need to have everything in their possession. We were assured that it's coming quickly. The ATF, for example, we expect to have their entire case file within the next week or so.
Richard Novak for Mr. Robinson. There's a connection between the discovery that we have not yet received, that the Utah County Attorney's Office has not yet received, and going back one layer further, the State Bureau of Investigation has not received, which is directly related to our ability to meaningfully prepare for the preliminary hearing. The federal forensic files. We're talking both about case files, as the ATF calls it, and data files from both agencies, which relate directly to forensic analyses, which led to forensic opinions, which it appears the state intends to move into evidence at the prelim, but we don't have most of the underlying data. We don't have data that we've been able to give our experts on stuff that relates to those opinions. We did meet and confer after yesterday's meeting about the fact that we need to ask this court to postpone the preliminary hearing for that reason. It's not little tiny bits of witness statements here and there and reports and some photographs that we're missing. From our perspective, this is core fundamental data that underlies expert opinions that the state wants the court to consider. And we have no ability to either get our own expert opinions or meaningfully cross-examine the state's witnesses, or frankly even call the forensic experts themselves.
Let's turn to the matter that's before us. As this is the defense's motion, I will turn to you for your argument and your request.
I know this court is kind of drowning in First Amendment briefings, so I don't want to delve too much into that aspect. We are asking the court to classify this motion and the attachments as private. The reason that we are asking the court to do this fundamentally is because we believe that the release of this motion and the evidence has a reasonable probability of impacting our ability eventually to impanel an impartial jury and for our client to have a reliable penalty phase should that occur. I want to start kind of with a little bit of a procedural history here. October, November, early in the case, the defense and the prosecution met and conferred about how the government would preserve evidence in this case. And when the government, the prosecution, and any law enforcement agencies sought to conduct testing that might impact the evidence in particular ways, they were to provide us notice. And if we could not come to an agreement about that, we are required to file something with the court to ensure that the testing doesn't move forward. That's what occurred here. We have the same concern that the state voiced in that initial email. Are we putting something into the public sphere that will inappropriately enter into the minds of potential jurors and impact the case? I don't want to talk about the evidence specifically in a public setting, so I'm going to choose my words carefully and maybe read a little bit more than I normally would.
Sure.
The evidence is important enough. It is important. It is evidence that will be at issue in the case. But it is also in process, which is the whole point of the underlying motion, right? It's in process. There is more to be done. There is more the state wants to do. So it is not in a position where we are going to be arguing about admissibility because it's not done. So what we're talking about is releasing preliminary evidence into the public sphere that has the potential to impact jurors. And it is important enough that we are concerned that it will sway people's opinions one way or the other. So we don't want to be putting out evidence as the defense that will sway the public opinion. We've already told the court we're not fighting this case in the public. We're not trying to sway the public in favor of our client's innocence. That's not what we're doing. I also want to address one issue that I've seen generally arising in this case, and I think it deserves some comment. There seems to be an idea that flooding the public sphere with information or evidence from this courtroom will somehow dispel conspiracy theories or shift public narrative. That in and of itself is concerning to the defense. We believe that preemptively releasing evidence that we needed to provide to this court in order for this court to make an informed decision is just one of those actions, is one of those things that will negatively impact our ability to have a fair proceeding for our client. So we are asking that the motion and the evidence be classified as private, that this court consider our client's unqualified right to a fair trial and a reliable penalty phase should overcome the qualified right of access at this point. We understand things may change. This evidence may come in other ways at other points in the proceedings, like a preliminary hearing or when we actually challenge the admissibility of evidence. But at this preliminary stage, we believe this is the appropriate course to take to protect the proceedings and our client's rights. Does the court have any questions for me?
Well, I do, but I'm going to wait till all of the defense has presented. Is there another attorney that's going to be presenting?
Yes, Mr. Burt is going to present on the other motions to classify if the court is prepared to hear that.
All right. Yeah, I want to hear all of it, and then I'll have questions for you all. Thank you.
Sure.
Mr. Burt.
Michael Burt for Mr. Robinson. I'm going to be addressing what I'll call the camera motion, the motion to restrict electronic media. So there's a motion to classify that motion as private, and then there's a motion to close select portions of the hearing that is scheduled for April 17th. And there are, of course, oppositions to those motions. If the court would like, I can outline what those are.
No, I'll have the other side. I don't want to deprive them of the opportunity of doing the same thing as you just did.
There's a lot of paperwork in front of the court, and obviously I'm not going to repeat everything in there, but one of the cases that's cited by all parties, Utah Supreme Court opinion in Kearns Tribute Corporation. There are a number of key points in that opinion that I'd like to focus the court's attention on. The issue there was whether there was a public right of access to a preliminary hearing. And the court goes on and says, as a result, the added risk of prejudice through pretrial disclosure of evidence targeted in a motion to suppress are not present in Utah's preliminary hearing. If the prosecution elected to try to use such evidence in the preliminary hearing in advance of a ruling on whether it should be suppressed, the defendant could seek special measures to avoid its public disclosure. So there I think the court is signaling that in a preliminary hearing context, if an issue of inadmissible evidence comes in, the appropriate procedure is for the defense to seek closure of at least that portion of the hearing where the evidence is going to be discussed. So the first point I wanted to make is court looking at the procedure we're asking to close a portion of, and that is the motion to preclude further electronic media coverage of the case. It is unlike a preliminary hearing in the sense that that hearing on the 17th is not going to include a motion to suppress evidence, obviously. It's going to include a discussion of the nature and extent of prejudicial pretrial publicity. The cases define that term as a term of art. It does not include all pretrial publicity. We are not complaining about all pretrial publicity. We're complaining in that motion to close the hearing, which is the motion to prevent further electronic coverage. Our only focus there is on what the courts have characterized as prejudicial pretrial publicity. That categorization includes the same type of information that prohibits lawyers from commenting upon things like confessions, evidence before it's been admitted, personal opinions as to guilt or personal opinions as to the appropriate penalty, evidence which is clearly inadmissible. Those are the categories of prejudicial pretrial information that the courts and the rule focuses on. So our motion to preclude further electronic coverage details, and what the media says in too much detail, the kinds of prejudicial pretrial publicity that have characterized this case so far. The standards that the court is governed by under the rulings that we cite, the Utah Supreme Court case says, in deciding whether there's a reasonable likelihood of prejudicial pretrial publicity, the court has to consider a number of factors. The size of the community. So as part of our burden, we have to show the court, through evidence, what is the nature and extent of the prejudicial pretrial publicity? And by definition, that prejudicial pretrial publicity is inadmissible at trial. We're dealing with a motion that by definition is putting forth in front of the court evidence which is clearly inadmissible at the trial of this case. Confessions, alleged confessions, opinions and statements by Ms. Kirk, statements by the President of the United States, statements, opinions by the Vice President, by the Governor, by the prosecution, by law enforcement officials. All of that prejudicial pretrial publicity is by definition inadmissible evidence. Is that the type of hearing that we're going to hold on the 17th that should be subject to a right of access, the first issue which Kirk says the court should consider? My argument to the court is that it's not. It's not a traditional procedure such as a trial or a preliminary hearing where courts have recognized a right of access. Even if there is any sort of right of access to a hearing on whether the electronic media should be excluded, the nature of that hearing has to be considered. I think the best description of the type of hearing we're talking about on the 17th is discussed by the U.S. Supreme Court in Estes versus State of Texas, which we cite in our pleading. In that case, like this one, there was extensive prejudicial pretrial publicity. And in that case, like this one, there was a motion to exclude further coverage by way of electronic media. And the court addressed the issue of whether that type of a hearing is something that in itself can give rise to prejudicial pretrial publicity because of the fact that the evidence that's being brought forth during that hearing is going to be, by definition, prejudicial. In Estes, Judge Clark's opinion says it is contended that this 2-day pretrial hearing, that is the hearing to exclude the press, cannot be considered in determining the question before us. And the question before them is whether Mr. Estes was deprived of his federal constitutional right to a fair trial. The court goes on, we cannot agree. Pretrial can create a major problem for the defendant in a criminal case. Indeed, it may be more harmful than publicity during the trial, for it may well set the community opinion as to guilt or innocence. Though the September hearing dealt with motions to prohibit television coverage and to postpone the trial, they are unquestionably relevant to the issue before us. All of this 2-day affair was highly publicized and could only have impressed those present and also the community at large with the notorious character of the petitioner as well as of the proceedings. The trial witnesses present at the hearing as well as the original jury panel were undoubtedly made aware of the peculiar public importance of this case by the press and television coverage being provided and by the fact that they themselves were televised live and their pictures rebroadcast on the evening show. So that kind of captures why we had to bring this motion, because we don't want to be in a position of inflicting another wound on Mr. Robinson's right to a fair and impartial jury by republicizing, either right now in arguing this motion or on the 17th when the court hears from us what the nature and extent of that pretrial publicity is.
Well, let me stop you right there,
Yes.
Mr. Burt. So you cite the Estes case, but Estes was overruled by Chandler v. Florida because in Estes there was an assumption of prejudice, but in Chandler it required the defense prove actual prejudice, and so it changed a little bit. Can you talk a little bit about that?
Yeah, certainly. The Chandler court, first of all, was asked to but did not overrule Estes. But what it did clarify, as the court just indicated, is that if the defendant wants to prove up a federal fair trial violation, it's his burden to prove prejudice. And the Estes court outlines that that can be done through an evidentiary hearing at which the defense would have the burden of showing, again, the factors under the James case, nature and extent of publicity, how it prejudiced the defense, whether there are reasonable alternatives. That's going to be the very purpose of the hearing, to comply with Chandler's mandate that we have the burden to prove that prejudice. We're going to be taking on that burden, and we think well established that we're entitled to the relief that we seek, which is some restriction on the type of prejudicial information that is flowing not only from the electronic media, but that electronic media being amplified by the widespread use of social media, which we discuss at length in the motion. I'm not going to get into the merits of the motion itself, but to address the concern the court had about, well, really Estes is no longer good law. Estes is cited favorably in Chandler. It's cited favorably in Hollingsworth versus Perry, which is the Supreme Court's most recent discussion of cameras in the courtroom. And the court is correct that Chandler put a gloss on it, that we have to show there is no presumption of prejudice, but there is a presumption of prejudice in regard to certain types of prejudicial pretrial publicity. The clearest holding in that regard is the Schilling case. Schilling says there is no presumption of prejudice unless certain categories that the courts have recognized as prejudicial are proven, and then it's inherently prejudicial. And the example that Schilling cites is publicity about a confession. And it cites back to the Wilbert Rideau case, Rideau versus Louisiana, where the court reversed the conviction because the defendant's confession was broadcast prior to the trial. So we have that type of prejudicial pretrial publicity in this case, and it's outlined in the motion. We'll show both that we have categories of prejudice, and we'll show that beyond that, the overall picture of this case is one of extreme prejudicial pretrial publicity that justifies the kind of relief we're asking for. But how do we show that without re-inflicting the very harm that we're seeking to avoid here? And that's the purpose of our motion. And the main concern is the tendency in this case for the press to, first of all, highlight all of the prejudicial information, virtually every story they feature on the case, which has its genesis in the prosecution's initial press conference before the court imposed its publicity order. There was an extensive press conference which got before the public a great deal of the kinds of evidence which should not be disclosed before the court had the occasion to enter that order. And then that evidence has been re-amplified, commented upon, so-called experts have been brought in, lip readers, body language experts, all of that is outlined in the motion. The kinds of reiteration of this prejudice we're most concerned about. The best example of that, the reply brief on this closure issue. At page 6, there is a link to an article, and that article concerns a story by one of the media's clients in which they were supposedly reporting on a defense anticipated motion to modify the court's publicity order. It's a television story, and the court has to see it to understand what the issue is, but the story does not concern what the merits of the motion is. The story focuses on, let's repeat for our audience in a very dramatic fashion all of the prejudicial statements made by politicians from the president on down, characterizing Mr. Robinson as an animal, characterizing him as evil, characterizing him as deserving of the death penalty. And they string together all these quotes and rebroadcast them. And that's the kind of coverage that's, I cite that as one example. But if the court sat down and touched on all the links we have in the motion, the court will see it's repeated over and over again. So we don't want to be in that position of putting in front of the court all of this prejudicial information, then having the press regurgitate it yet one more time and re-inflicting the wound that we're seeking to avoid. The third point from that case is the standard that governs what we have to show. And the court, in the opinion, says we don't have to show a clear and present danger to Mr. Robinson's right to a fair trial, but a realistic likelihood of prejudice. And if the court looks at the standard for excluding electronic media, it's similar: reasonable probability, reasonable likelihood of prejudice. That's the applicable standard the court will apply. In terms of the other remedies that are being suggested, neither the state nor the media cites what I think is a controlling case on this issue, which is Gentile versus State Bar of Nevada. There, Chief Justice Rehnquist, writing for the court, who is no fan of the criminal defendants, said, quote, "Even if a fair trial can ultimately be ensured through voir dire, change of venue, or some other device, these measures entail serious cost to the system. Extensive voir dire may not be able to filter out all of the effects of pretrial publicity. And with increasingly widespread media coverage of criminal trials, a change of venue may not suffice to undo the effects of statements such as those made by petition." I don't know how many capital cases that media lawyers have been involved in, but for the last 40 plus years, I've done nothing but those trials. And I've been involved with using jury questionnaires, extensive individual sequestered voir dire. And the fact of the matter is that voir dire is not an effective means in these cases. And to the extent it is effective in excluding people who hold prejudicial opinions, it calls into question other rights that are implicated. For instance, in a death penalty case, the jury has to be death qualified, both those who would automatically impose death and those who would automatically impose life. There's a lot of research which shows that that process skews the panel as unrepresentative. It excludes people who are knowledgeable because they read this media coverage. It excludes, the evidence shows, minority groups, women, and people that normally would be included in a representative jury. So yeah, you can voir dire a jury on whether they've heard the President of the United States say that Mr. Robinson should be executed, and you can exclude that juror from serving on this case. But given the demographics of this county, you're going to be excluding a large portion of the population. And then when you add to that the death qualification process, you no longer end up with a representative jury. You end up with what the U.S. Supreme Court in Witherspoon versus Illinois called a group organized to return a death verdict. But it's not a representative jury. So as Chief Justice Rehnquist said in his opinion, even if you employ these other means, they come with a great cost, and in this case, a great constitutional cost. So those are the main points I wanted to make to the court, and I hope I haven't repeated things that the court is already familiar with, but I'm certainly happy to answer any questions the court may have.
Well, what I think I'm going to do is wait till the state makes their argument, and then I'll have questions. That's going to put the picture together for
Great.
me, and then have questions for all parties. I just want to make sure I hear it all, and I appreciate your arguments, Mr.
Makes
Burton.
sense. Thank you.
Turning to the state.
Your Honor, Christopher Ballard on behalf of the state.
I deserve to be killed because I left Islam and became a Christian.
According to Islamic law, an apostate like you would be killed. Yeah.
Yes, absolutely they'd be killed. That's required, it's necessary. This has gone on for many, many generations. Muhammad is a warlord. He is a dangerous and murderous leader, and so his followers become those things too. In Egypt, When you're born, on your passport, they put, or your birth certificate or whatever, they put your religion. And so if your parents are Muslim, they'll write Muslim. Many Egyptians leave Islam, but they will never correct the paperwork because this sends out a signal to the Muslim community around them that they should be killed now. That is Islam. Islam is murder.
This year I decided to brighten up my life and to brighten up my yard by planting roses. And this was my first time to try to grow roses. Now, when I was in school, our science teachers taught us that nature abhors a vacuum. But I've learned something else that nature abhors: a rose garden. And anybody who's ever tried to grow roses, I'm sure, understands what I'm saying. As soon as one engages in the enterprise of trying to grow roses, he understands very soon that he is involved in an international, intercosmic conspiracy. All of the forces of nature converge against the person who would grow roses. I thought it was an easy thing. You know, just dig a hole in the ground, put the rose in there, put some water on it. I mean, most plants need certain things to grow. They need water, they need sunshine, they need a little bit of fertilizer, and that you don't have to worry about. But there must be 10,000 insects that love roses. Not to mention a host of other bacterial infections that are out there, invisible to the naked eye, waiting to pounce on your rose bush as soon as it shows the slightest bit of growth and health. All of the work that goes into producing one rose is an analogy of the Christian life. Because I've discovered that to grow roses is not recreation. It's war. It's a battle, a daily struggle, not something that you can look after every 3 weeks, for by then the weeds, the parasites, the insects come in and destroyed what you have tried to work on. But roses need attendance daily. And so it is in the growth of the Christian life.